In court, how can you tell the difference between an attorney who's fully prepared and one who's not? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. You will notice a dramatic difference between an attorney who is fully prepared and one who does not prepare. Now, anytime you try a case, whether it's an accident case or a medical malpractice case or even a wrongful death case, the most important part of the entire trial is the preparation that goes on before the attorney ever walks into the courtroom. Because the attorney needs to know every single detail of the case. The attorney needs to know where every single document is. The attorney needs to know what his agenda is. He needs to know what evidence he has to introduce. The attorney needs to know what legal objections are going to arise anytime a certain document or a certain piece of evidence is going to be introduced. The attorney has to anticipate what arguments, what legal arguments the defense is going to raise and prepare for them and have legal case law available. So now when the judge says, "Counsel, do you have any case law in support of that request?" Now I can go ahead and hand that up to the judge. It is critical to be fully prepared. So how do you know the difference? Because when you go into court and you're sitting in the back watching, you will know immediately the difference between a fully prepared attorney and one who is not. A fully prepared attorney knows every single argument. He knows every single detail of the case. On the other hand, an attorney who is not prepared is fumbling with his words, fumbling with his arguments, fumbling with pieces of paper, trying to find things, trying to find his documents. He's disorganized. That's someone who clearly is not fully prepared. And does it make a difference? The answer is absolutely. Because your credibility, the attorney's credibility, means everything. And just by being prepared, now the jury can focus on what they need to, the facts of the case. They can focus on the issues in the case, and not seeing an attorney bumble around trying to figure out for 5 minutes where his documents are, not asking the judge for multiple recesses, not telling the judge to hold on 1 second because he's got to find a document. That's not being prepared. So why do I share this quick tidbit of information with you? I share it with you just to give you an insight and an understanding into what goes on in a trial here in the state of New York involving civil lawsuits. You know, I recognize you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you've got legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.